Hello everyone and welcome to Legal Briefs. I am attorney Jeremy Hogan and this is the weekend version of Legal Briefs. No, not that weekend, but the Saturday-Sunday type. And today I'm going to be talking about the SEC lawsuit against the crypto industry because that's really what it is. And also honestly because I don't have the energy to talk about other things right now. So let's stick to the case at hand. And there's a lot to talk about in the SEC versus Ripple case because there's a hearing coming up on Tuesday the 31st, and it's more important than I think most people realize, and it's central to a big gamble that the SEC took a couple months ago in the litigation, and I want to tell you about that gambit and how it has and will affect everything that happens in the case. And then at the end, I want to address YouTuber BitBoy's prediction of settlement in September and give new timelines for the case. But first, and most exciting for me, as you may know, the digital asset investor and some other members of the XRP crowd have been doing overtime on the research about the SEC and whether it ever made a determination as to whether the Ether token is a security. And I did my own research, and this is amazing. I have found a video which actually shows the meeting between the Ethereum Foundation and the SEC, which took place at the Foundation headquarters, and proves conclusively that the SEC told Ethereum that the Ether token is not a security and shows how it arrived at that determination. Roll it.
Call it. Call it, yes. For a whole lot. Just call it. Well, all right. Heads then. Well done. Don't put it in your pocket, sir. Don't put it in your pocket. It's your lucky quarter. Where do you want me to put it? Anywhere not in your pocket. Or it'll get mixed in with the others and become just a coin.
And that, my friends, is how the SEC determined that the Ether coin is not a security, but just a coin. Welcome back, and my lord Javier Bardem was amazing in that movie. Amazingly creepy, that is. In any case, we have a lot to touch on to get you up to speed, so let's get to it and start with the motion that is coming up for hearing this Tuesday, August 31st, which is Ripple's motion to compel production of internal SEC documents which show the SEC's views on whether Ether is a security or not. Now, remember, there are two main issues in this case. One, whether XRP is a security, and two, if it was, whether Ripple had fair notice it was selling an unregistered security. So there's two issues going on here. At the earlier hearings on this case, the judge seemed very interested in Mr. Hinman's 2018 speech stating that Ether was not a security. And there's only one reason she'd be interested in Ether, and that is because the court is willing to compare XRP to Ether as far as to whether it's a security or not. Otherwise, Ether's security status is completely irrelevant in this lawsuit, and that would be the only reason why the judge would ever be interested in Ether. So Ripple's lawyers knew the court would find this important, and so did I when I first read about it back in January this year. Now, here's what I said when I first noticed that the fence was taking shape. This is from January.
But really briefly, I just want to point out what some of the best lawyering on Ripple's behalf is that I've seen so far. Now, along with the answer, Ripple filed a request under the Federal Sunshine Law, which I think is the FOIA, which asks for documents pertaining to the SEC's informal opinion that Ethereum is not a security. Here's a story about it. Now, the story says that the defense gets desperate. I would very strongly disagree with that headline because this is not a desperation move. This is genius. As I told you in my last vlog, if you listen to the SEC's legal arguments, Ethereum at one point was definitely selling securities. So why the proclamation in 2018 by the SEC that Ethereum didn't sell securities? Ripple has apparently found a chink in the armor and they're going for it. Who knows what they'll find in there, but this issue will put the SEC on its back foot. Very subtle, but very good, Ripple. Make the SEC defend itself for once.
I love self-referral to myself as an authority. It makes it so much easier. I wish I could do that in court. And back in January, I was correct because we've seen the judge during the very first hearing in the case and in the second hearing, which I think was the April 6th hearing, show a lot of interest in what Mr. Hinman said about Ether. And I would argue that the SEC's position on Ether is not only important to the fair notice defense, but also to the underlying is XRP a security issue, because the court seems open to comparing the two tokens and basing part of its decision on that comparison, which I think the SEC has caught on to, and that is why it is backtracked and said that Hinman's speech was only his personal opinion and not an official position of the SEC that Ether is not a security. So, the discovery is relevant not only to the fair notice defense, but also to whether XRP is a security. I think everyone understands how the SEC's thoughts on Ether are relevant to the fair notice defense, but the thing I'd like you to understand going forward is that it's going to be relevant to the underlying issue as to whether XRP is a security. To lay it out for you, here's what the judge said back on April 6th at the hearing. This is on page 9 of the transcript. Judge Netburn says, quote, "Because as I understand it, the defendants are saying, well, actually, there are many ways in which they are similar." She's talking about XRP and Ether here. "And we are at discovery and we are entitled to pursue our own defenses, and one of the defenses that we are going to make, maybe we will be successful and maybe we won't, but one of the defenses is, hey, we are just like those guys, and so we want to build up that defense." So there the judge was talking about XRP comparing itself to Ether, and she was validating that point of view. So as we know, she did allow the discovery after that hearing regarding the SEC's thoughts on Ether, and if she really thought it wasn't relevant, she wouldn't have allowed the discovery of it. So that's why the hearing on Tuesday is very important. These documents potentially go to both of the major issues in this case. But don't take my word for it. It's also pointed out by the one and only Attorney Matt Solomon in his reply brief, in which he reminds the judge that she said it, and here that is in his motion. Quote, "But the court already found this discovery is relevant to the court's eventual analysis with respect to the Howey factors." April 6 hearing, transcript at 51:11:17. Now if you're interested, those numbers at the end tell us what page and lines to look at on the hearing transcript. So that's page 51, lines 11 through 17. So in other words, this upcoming hearing is very important because Ripple could potentially get some documents that it could really help it advance its position that XRP is like Ether, and in 2018, the SEC said Ether is not a security, and therefore XRP is not a security. So this will be the focus of the next 2 months of discovery, which is expert discovery, where very smart people will talk about decentralization and nodes and supernodes and ICOs and block mining and all that kind of stuff. And this is why I love practicing law, because it really is like a chess match. Great acting in that show by Anya Taylor-Jones. And in a very real sense, the SEC has deployed a Queen's Gambit in this litigation, sacrificing its position on the fair notice defense in order to solidify its central position that XRP was sold as a security. Allow me to explain. The first move here was played back in January with Ripple's focus on Ether and documents about how the SEC analyzed Ether and the focus on Mr. Hinman's speech. The SEC was hoping that going into the April 6 hearing that the judge was not going to bite on the relevance of Ether status, that she would say, well, what's that have to do with XRP? Now those hopes were quickly dashed by the judge, as we just saw in the transcript. So the SEC played its gambit, which was this in Mr. Hinman's affidavit, filed to try and protect him from being deposed. Looking at number 13 in his affidavit, quote, "The speech was intended to express my own personal views. To the best of my knowledge, the Commission had not taken at that time, and still has not taken, any position or expressed a view as to whether offers and sales of Ether constituted offers and sales of securities," close quote. And thus the gambit was set in motion, and this was it. The SEC was going to, in a sense, admit to some extent that there was confusion in the marketplace about digital securities in exchange for strengthening its position that XRP was a security. Because if Hinman and the SEC had taken an official position, there would be more certainty for other crypto coins, but in turn that would allow Ripple to argue that XRP was just like Ether and therefore not a security. So the SEC went down the road less traveled, and that has made all the difference, as Frost says. That one decision has colored everything that has happened since, and is the main reason Ripple is going to be able to slam this fair notice argument on the SEC. Look at all the wondrous joy that this move has made possible for them. And before pointing these things out, let me just give a shout out to the digital asset investor here on YouTube. I don't know how he does it, but he finds the most amazing things online. So keep in mind that the SEC is saying basically, we never had a position on whether Ether is a security. And here we have this from the day after Hinman's speech. This is from Commissioner Pierce. As you can see there, she calls the speech, quote, "a positive step in the SEC's relationship with innovation," close quote. Now obviously she didn't get the memo that this was just Mr. Hinman's very personal thoughts and feelings expressed in his speech. And another SEC commissioner apparently never got that memo.
Named Bill Hinman, who did he gave a speech where he laid out, here's how we think about this, and gave a set of principles that the market can follow in understanding, here's how you know if you have a security or if you don't.
And apparently even Mr. Hinman himself didn't get his own memo because there's no I's in his W's.
In Ether transactions, we keep gathering information, and at some point we say to ourselves, well, this is something that we should make clearer. In its current state, we don't see value regulating it. So we're trying to be transparent and practical as we provide more guidance.
Or maybe Hinman just wants people to refer to him with the pronoun we. Just saying. But the point being that these videos and clips, I mean, you could go on and on with them. They're all over Twitter and all over YouTube. And at some point, I think Ripple's just going to have to make a top 5 list and go with it to demonstrate to the court the confusion that was and is still in the marketplace for its fair notice defense. And of course, I wouldn't want to leave out what to me is perhaps the ultimate piece of evidence of market confusion, which is this email from the SEC to an individual who asked the SEC whether XRP was a security or not. And this was the SEC's response. Quote, "Please be advised the SEC has not issued a determination on whether the cryptocurrency XRP is a security," close quote. And that email correspondence was dated October 14, 2020, 2 months before the lawsuit was filed. I guess the SEC staff who wrote that email didn't get the memo that Ripple was about to be sued. Whoops. But these things were part of the gambit that the SEC took here, and it's not really an illogical position. First, recall that the SEC moved to strike Ripple's fair notice defense, and I've already said that I don't think the defense will be stricken, but the SEC has a lot riding on that motion, and it plays into our timeline, which I will explain in a second. But there's at least a possibility that the SEC wins that motion, and a lot of this stuff would then become irrelevant. So that's a big motion. And by arguing that the SEC took no position on whether either is a security or not, it can now argue that any comparison between the two is irrelevant. That's the trade-off. Now, whether that argument works is complicated, but the gambit at least allows them to make that argument. So keep that in mind as we see the next couple of weeks unfold. But just understand that the SEC is playing a dangerous gambit which gives a lot of ground on the fair notice defense while trying to strengthen its argument that XRP is and was a security. And finally, I want to briefly talk about timelines for everything. And yes, here's where I speculate, and everyone hopes I fall flat on my face for your viewing pleasure. We recently had a joint motion to extend discovery, meaning both parties were agreeing to it. Apparently a lawyer got sick, and so the Brad Garlinghouse and Chris Larson depositions could not go forward. So they are being pushed to September 14 and 20 respectively. Remember, lawyers are human and get sick and take vacations. We are not all blood-sucking leech robots. Now this does a couple things, and here it is in the joint motion, which was granted, by the way. Looking at page 2, second paragraph, quote, "Accordingly, the parties respectfully request that the court correspondingly extend expert discovery until November 12, 2021, with opening expert reports due on October 4, to allow for the same amount of time between completion of these depositions and expert reports as under the prior schedule," close quote. So basically the entire schedule is being pushed back 3 weeks, with discovery not concluding until November 12th. Now, I recently started watching BitBoy Crypto on YouTube. He has a really cool YouTube channel, and he's so good at talking off the cuff, very impressive. He even talks about XRP while driving to church in the morning. Hallelujah. But according to him, the Ripple case is being settled in mid-September, and here he is saying that, I think.
Again, do you guys want another prediction that's going to come true? I said it the other day. We are going to see this settle by mid-September. Mid-September. About a month away, we are going to see this get settled. Could be much quicker than that. It could be much quicker than that, but by the middle of September.
BitBoy, do you play any instruments? Drums, maybe? Let's do this thing. But props to him for throwing a prediction out there. My prior thoughts on settlement were predicated on an unprecedented lull in the litigation right when things should have been picking up. And of course, 3 days later, the litigation picked up again and I had to backtrack. But what BitBoy is saying is not impossible. Settlements can happen anytime. I literally settled a case in the bathroom of the courthouse during a bathroom break during the trial of the case. It's a long story. The problem with a settlement between now and November 12 is that the parties won't know how strong each side's position is until after discovery closes. So even if we are looking at a slap on the wrist settlement of millions of dollars, it's kind of funny to say, how many millions are we talking about? 10, 20, 200, 1,000? You think that Ripple isn't going to care about the difference between paying $20 million versus $200 million? I think any business cares about that and is willing to wait an extra couple months in order to potentially save millions of dollars. And from the SEC side, how can it settle without knowing the fate of its motion to strike Ripple's fair notice defense? The SEC's Queen's Gambit has put a lot of weight on that motion, and it's still not resolved, and the judge has not told us when she's going to make a decision on it. So we're still waiting on that. Now, I want to admit something to you that I don't tell many people, and is a source of some shame for me. When I was younger, just out of law school, I worked for insurance companies for a couple years. Yes, I worked for State Farm, Progressive, all of them. It's not a period of my life that I like to talk about too much. But in any case, when we had a bad factual case, a case we were likely to lose, we'd move for summary judgment on the problem issue to try to keep it away from the jury. And literally the conversation between myself and the litigation adjuster went something like this. I'd say, let's get our motion for summary judgment heard, and if I can't get the judge to bite on it and get that issue thrown out, I'll approach the other side and we'll get the case settled. In other words, we'd either bury the problem or pay it away. I called it a bury or pay case. And I see kind of a similar hallmark in the SEC's motion to strike the fair notice defense. The SEC has so much riding on that motion. I don't see much impetus for them to settle until that hearing is heard. In other words, if they can't bury the defense, they just might turn around and pay, which in our case would mean get the case settled. Because what I know for a fact is that Ripple wants this case over with the caveat that the markets have to feel comfortable with any settlement and XRP gets relisted. Which means that the problem child here is the SEC. And if the SEC's gambit fails, that's when the litigation has the best chance of resolving. Otherwise, we are still looking at the Ripple case reaching the judge on summary judgment in early 2022. But for the time being, here is where things stand. Blacks move. Thanks for watching, and I was just kind of thinking that life is kind of like one big gambit, sacrificing smaller things in order to gain the big things in life. Enjoy the game, my friends.